Dear law students, advocates, court officers, and faculties, good evening. Today the topic is beginning of court work, that is in the open court. First of all, every student on completion of the course in law college very eager and curious to enroll themselves as an advocate. Because until unless they enroll themselves as an advocate, they are unable to come to the court and practice. They would have some dreams like how the experience would be in the open court. So therefore the problem is fear also will be there, like stage fear, in court also, open court also, fears are there. Because the reason well versed persons are there sitting around, and in front of them we have to speak to the judge, represent the clients and argue the case. That is very important. So this makes in a man a fear. Okay. Okay, once enrollment is over, the next day we come to our place where the court situates and we are going to appear in the court. First of all, we should choose a senior and get his permission to join with them to handle the cases. Because if you are not having a case in your hand, because you are a raw person and just now got yourself enrolled as an advocate, how you are going to conduct case? It is not a possible one. So therefore you have to choose and get his permission from a senior advocate in the locality. Already he will be having some cases, so that you can carry that bundle case to the court and make representation before the judges. This is the procedure. One can ask question as to, should I necessarily join senior? Some bright students are there. In a practical way, they would have pursued the law course. Therefore, they are ready to conduct the cases if they are having claims and cases in their hand. It is possible. Some people are there, found bright, and came directly to the court and started the procedures. Even though if you want to practice directly, you have to learn certain procedures in the open court. Some traditional ways are there being maintained, called calling hours. First of all, simply if you come and sat in the court will commence at 10:30 in the morning. Judges will sit on the chair 10:30. So after that, they'll call the matters, every matters, because they'll be in hand 100 cases, approximately 100, 150 to 200 cases sometime, according to the burden and workload of the court. So therefore, they will call the matter, and some matters, they'll adjourn the matter with some specific date, hearing date. And they'll take pass over some cases so that they will be tried after the calling hours. Usually it takes 12:30 to 1 o'clock calling hours to be completed. Then after that, they start 12:30, the trial of the cases. Every day they are able to handle the trial 5 to 6 cases only, not more than that. Partly they will hear the matter. It is called parted. So parted matters. Once matter, the judges started to hearing no. Today they started no. The next day it becomes parted. Partly had. That means. So the parted matters will be next day, day after tomorrow. So it will go on for 10 days or 15 days, 20 days, the whole month to be finished. Once the matter kept for final argument for defendant side, after that judgment will be delivered by the judge. This is the procedures. You have to understand all these things, how calling hours. So you should keep in mind that IAs are there. What is IAs? Interlocutory applications. Suppose a person filed a case before a court. the same day will not be adjudicated, that matter will not be adjudicated, judgment will not be delivered on the same day in the lower court. Sometimes it happens in the high court, disposal in the same day. But lower courts, they have to go through the case completely, and evidences to be advanced by every person, the person who sues and the person who is coming the other side. They have to put their evidences before the court, and after hearing the evidences and documentary evidences and any other materials, then the court will deliver judgment. It takes more than a month. So usually the court is in a capacity of disposing 18 to 20 cases. In an excellent way the court behaved, then there will be 22 cases disposed. That's all. So the other cases will be uh, carried on the next month, next month, like that. Okay. So calling hours means first they will call IA, interlocutory application, because some urgency will be there. When a case is filed, some urgency will be there. In order to meet the urgency, they will file an interlocutory application, that is IA petition. And for that, a counter is to be filed by the other side. So both the petition and counter and the argument, enquiry argument over it, after hearing all these things, the court will deliver an order whether stay is to be granted. Like injunction is mostly granted in civil court, and criminal court 125 CRPC and all, the interim maintenance they grant like that. Okay. So once the injunction was granted, after hearing both parties, the petitioner and respondent, that is the plaintiff and the defendant, then the injunction go on being extended, or otherwise it will be made absolute till the disposal of the suit. Then till the disposal of the suit, it will be in existence, and final judgment will be passed on the after 2 years, 2.5 years. In olden days, it took more than 15 years for a case to be disposed. But nowadays, all had put their effort, judiciary and the government and also the advocates. Therefore, it is now a reasonable time. It is to be 2 years, so that the case will be completed by the court. 2.5 years, not more than 3 years. Mostly 3 years, the court tries to complete the matter with a judgment. So one should keep in mind that first calling hours, year wise they will call. Year wise, they'll start the older one, then the next year, like that. So you have to patiently watch the calling. The clerk, the bench clerk, he will be calling the matters orally, and you have to understand the number and year, whether you have to understand this is your case. If it is your case, then you have to stand up and tell what you want to do. Otherwise, you want to get adjournment to the next hearing date, because all the cases are not right to trial. Suppose an advocate who is appearing for a case, he didn't stand up and didn't represent, what will happen? Nothing will happen. They call by name, the advocate's name. Mr. Sundar for the plaintiff, Mr. Suresh for defendant. So in such a manner, the bench clerk will call. Even the advocate is not appearing, both sides, then the court will call the parties to be present by name, the plaintiff's name and the defendant's name. The court would call the party's name. Then they have to come and appear before the court. Even if they are not coming and appear, then the client may lose the matter. ex-parte injunction or ex-parte judgment will be awarded, or otherwise the suit will be dismissed. So the consequences is like that. So the advocates, junior advocate who is coming fresh to the open court, they have to very carefully, patiently look into the matter, look into the calling, understand the case number and years, then represent to the court if necessary. You have to obtain a note from senior advocate so that gradually in a month or two you can understand what is the next stage. You yourself understand, and the next after 3 to 4 months you can come straight away without getting any notes. You can make representation if your senior allows. Thank you. Subscribe, share, like, and also you click the bell icon while subscribing. Thank you.